Our first case of the morning is case number 126795, Richard L. Dent et al. Versus Constellation NewEnergy et al. Are you ready to proceed, Mr. Eaton?
Yes.
Mr. Nealon?
Yes,
You may proceed.
Good morning, Your Honors. My name is Tim Eaton, and I represent the appellants, Constellation, in this matter. This court has never had the opportunity to weigh in on whether there should be a conditional privilege for alleged defamatory statements made by victims, witnesses, or investigators during the course of an investigation of sexual harassment, so as to defeat any defamation suit by the alleged harasser. The appellate court over 20 years ago in Vickers versus Abbott found such a conditional privilege under these circumstances, and that privilege has not been challenged in this proceeding, either in the trial court or in the appellate court. So we would ask, importantly, that this court affirm the conditional privilege when statements are made during the course of such an investigation. But the more important issue, which is in contention both below and in the appellate court, is what must be pled in the petition to overcome the conditional privilege in considering whether a Rule 224 petition should be dismissed or a complaint of defamation should be dismissed. This is a critical issue because it relates directly to whether victims of sexual harassment will continue to be willing to come forward with their allegations. The appellate court found that a Rule 224 claimant need only allege that the statements were false or not privileged to sufficiently allege that the privilege was abused. But such simple, conclusory allegations of abuse of the privilege will hardly deter retaliatory claims against victims. This would turn the focus instead on the discovery of the victim, not the harasser. The plaintiff in a defamation case where a conditional privilege applies must, as the appellate court held in Vickers and this court held in Kuick, although different circumstances, but a conditional privilege was at stake, is that there must be evidence or allegations that not only they were false, the statements were false, but the people who made the statements knew they were false or had a high degree of knowledge that they were false, or they must allege facts that shows there was a reckless disregard for the defamed parties.
Counsel, was the privilege contained on the face of the 224 petition?
Yes, it was.
Because is there something in there that shows that the person A was an employee?
That person A was an employee?
Right.
I'm not certain whether it says it's employee, whether she was an employee or not, but we know that there was a complaint made by her and there was an internal investigation by the employer, so one would assume that she was an employee, but I'm not sure that would make a difference. It could have been someone that they had hired to be at that event for purposes of servicing the participants. So whether she was an employee or whether person B was an employee doesn't make any difference either. Person B was a witness. But
Mr. Eden, isn't
yes.
this a matter that could be better resolved in a summary judgment proceeding?
No, Your Honor, because this court held in Hadley that where you have a claim of defamation, that you may file a 2615 complaint to determine, a 2615 motion to determine whether the complaint even states a cause for defamation. And in that case, they looked at the defamatory statements and they decided that it should go forward. But the cases they adopted in that case, Maxson versus Ottawa Publishing Company and Stone versus Paddock, both said that if the statement is not defamatory, then it should be dismissed at that stage, at the 2615 stage.
But 2615 is to determine the sufficiency of the complaint.
That's correct.
Are you saying that this complaint is insufficient?
Yes, I am.
And how's that? Why is it?
Because first of all, it alleges a privilege that's clear from the statements that were made in the 224 petition, and more importantly, too, in the letter that was attached as Exhibit B to the 224 petition. It states in there categorically that this was an investigation by Constellation. They had third parties conduct interviews and so forth. So the conditional privilege is, as I mentioned to Justice Burke, the conditional privilege is alleged in the complaint, but what they have to allege further is that that privilege was abused. Because if it's not abused, then the privilege alone would protect the identity of the victim in this case. And to go forward in a summary judgment would require the identification of the victim, discovery with respect to the victim, and then the victim in that circumstance would be put to the test of not only having their identity known, but having to pay for litigation, defending herself in a defamatory action. That step should not occur unless the petition itself has specificity that the privilege was abused and therefore we can go forward. Absent that specification, then a 2615 petition is appropriate. Now, there may be circumstances, Your Honor, where it's not clear from the petition that was filed that the conditional privilege applied or that there was an abuse, and that could be raised in 2619. That should also be allowed, that one, there's a condition, and two, it hadn't been abused. But this case, face of the complaint, fails to state a cause of action for defamation. Because to state a cause of action for defamation, one, the statement must be false. Two, it must be made in an unprivileged context. And three, there must be damages.
Averring that the statements were false is not enough.
No. Like I said,
How does one prove a negative? How does one prove that something didn't happen?
there must be some indication in the petition itself, other than the statement was false, such as, this was someone who I knew, she had harassed me before, and therefore her credibility is at issue and it's false. I was with somebody at this golf outing the entire time, and he says that nothing like that occurred. Something more than just the statement's false. Because in a defamation case, that's one of the criteria, that number one, it has to be false, or number two, it has to be unprivileged. And to show unprivileged, this court has been very clear to show an abuse of privilege, that the person making the statement knew it was false, had a high degree of likelihood that they knew it was false, or there was some recklessness. Like in Kuwait, this court found that they could go forward to a summary judgment because the investigation was shoddy. It was faulty. They hadn't, I believe in that case, they hadn't, in determining whether or not this person could practice under her license, they hadn't even gone to medical personnel within the insurance company. None of those factors are here. All he said was it's false and unprivileged, which sort of begs the question.
This was a 615 petition, correct?
It was.
There was not a 619 or a 619.1?
Correct. So what we believe this court will have to do in reaching its decision, as a matter of policy, balance what's at stake. And as we said in our brief, what we believe here is the test. In ordering the disclosure of a potential defamation defendant's identity pursuant to Rule 224, this court must balance a potential defamation plaintiff's right to redress against the danger of setting the standard to prove an abuse of privilege so low that it effectively chills the victim's right to speak confidentially and exposes the victim to a retaliatory response.
Counsel, what I'm having trouble with is if you don't know the identity of the person making the statement, how can you make sufficient allegations? I mean, you've heard that they said you did something, and you say I didn't do it.
Right.
So how can you how could you gain enough information to overcome that privilege?
Well, Your Honor, this has been the case that this court faced in Hadley, and in the appellate court has dealt with these situations before where they were trying to ascertain what the identity of the person who made the statement was. In those cases, they examined the defamatory statement and determined whether it was defamatory or not. And if it wasn't, then it couldn't go forward, and the identity did not have to be disclosed. In this situation, what you have is you have to balance the rights of the plaintiff to redress, but with the rights of the victim who, in an interview, assumed confidentiality, which is important, as the amicus brief points out. So this court has found that in Kuwik, it even said that in order to facilitate honest communication, even sometimes protecting misinformation, that they have to err on the side of honest communication and people coming forward with this type of statement. And most of the time, as the amicus brief points out through their studies, I think it's been like less than 5% of the time the victim statements are inaccurate. So in the balance between the two, it seems to me this court should weigh in favor of not allowing the victim's name to be exposed. Because again, the studies have shown that in combating sexual harassment in the workplace, less than 14% of the workplace sexual harassment victims report their harassers. Most of them don't report because they fear retaliation and because confidentiality concerns are part of why they don't come forward to complain. And studies also show that approximately 3 in 4 women interviewed who did report a workplace sexual harassment were subject to some form of retaliation, including but not limited to defamation suits. So where there's nothing to indicate that the victim's statement was made knowing that it was false, or with a high degree of likelihood that it was false, or the investigation itself was reckless. Because the context we have here is that we had an investigation that no one has alleged was faulty. They interviewed the victim. They interviewed a witness that related the intoxication state of the petitioner at the time. And the investigators interviewed Mr. Dent. And based upon that process, they determined that there was a sufficient basis for the complaint. So there are protections built into the process, even though the petitioner isn't going to know who the name of the victim is. There was a complete investigation, and that should insulate the victim's name unless they can come forward with something that indicates, under these circumstances, she must have known it was false because, number one, it wasn't there, could be one. I was with someone who was with me the entire time, and they never heard it either, and that could be alleged. But in that balancing test, it seems to me this court has to come down on the side of allowing the victim's name to be confidential unless there's some indicia that the privilege has been abused. And here, there is none. Now, there was another issue raised by counsel in their brief with respect to how do you determine whether the abuse of privilege was abused in a case such as this, where it's only on the basis of a pleading. And isn't that normally a fact issue, like this court held in Kuwait? This court did say it was a fact issue, but in the context where there was some evidence that it had been abused. There's no evidence, there's no pleading, there's no allegation of abuse anywhere. So this could be decided as an issue of law. We raised the conditional privilege in our motion to dismiss under 2615. The trial court decided not to base her ruling on dismissing the petition on the conditional privilege or whether it was abused, but on what's been referred to in the briefs as a low-cost mover's defense. And that is, under 224, if there is one name of a person who may be responsible in damages, then the petition should be dismissed. And again, the court cited to the First District Appellate Court opinion, which this court has never dealt with, under 224 that since the petitioner already knew the identity of one of the persons in the investigation, person C, the investigators, that the purpose of Rule 224 has been met. There's been a lot of back and forth as to whether or not they knew the identity of one of the participants in the investigation, in this case, the investigators, person C. We believe, first of all, if you look at the Exhibit B to the petition that was filed, it clearly identifies in a letter written by Constellation to Mr. Dent's counsel that there was an investigation, that the people who were engaged in the investigation, their names were named, met with Mr. Dent, heard what he had to say, met with the other people, and although he denied the allegations, his denials were not credible, and the investigation concluded the reports accurately described their behaviors. The names are known, they're listed actually in the petition. They don't list them as person C, but they say they met with him on September 14th, 2018. In Exhibit B, we point out there was an investigation. These are the people that met with him. These are the people who made the conclusions. So he knows. But in a motion to dismiss, we also identified person C as the people that were identified in Exhibit B. So allowing this to go forward serves no purpose. He knows both through his own pleading, through our motion to dismiss. The trial court certainly determined that person C had been identified. So the purpose of Rule 224 was met, and therefore the petition was rightfully dismissed. Now the appellate court, on the other hand, believes, one, the person C had not been adequately disclosed, ignoring the fact that we had admitted in the pleading who it was, and it stated in the letter who it was. But they also said, well, person C are attorneys, so therefore they're not going to be liable or responsible in damages. There may be a privilege raised, so therefore we don't find that's an adequate disclosure of someone who may be responsible in damages. But I would repeat that Rule 224's intention is to find one person that's set forth in Section 1 who may be responsible in damages. It doesn't say, and you can overcome any affirmative defenses like attorney-client privilege or conditional privilege or whether they were participants or not. The appellate court simply went too far. And if the appellate court opinion is allowed to stand, then what will happen is people will come in with 224 petitions and they're going to be engaged in full-fledged discovery, trying to match people to their causes of action. And that shouldn't happen. And this court has not addressed that. The appellate court has been all over the board. Quite frankly, there have been some opinions which have allowed more than one person's name to be identified. We don't think that's correct under a fair reading of Rule 224. We think the appellate court in this case erred by suggesting that, well, even if you knew person C, they couldn't be held responsible in damages. Well, how do you know? We don't know what defenses are going to be raised. We don't know what the fate of those defenses would have been. So in this case, person C was known, and that is another basis for determining whether or not this petition should have been dismissed. But, Your Honors, that would be kicking the can down the road on the privilege, quite frankly. What really is at stake is whether in the context of a workplace investigation of sexual harassment, this court will provide some protection that women need to report this conduct without fear of being further harassed by a retaliatory defamation suit. We see what's happened in this case. Put my client aside, a small business, an individual who made this report and there was an investigation. Would she be expected to defend a Rule 224 petition, a Rule 2402 petition, which counsel says if we don't know the name, we can go to the next step and name Constellation Respondent Discovery? Briefing in the appellate court, briefing in this court, 2 motions to strike in this court. At some point, she's going to say, I give up. I can't afford this process. So it's not just in this case where the employer may have the wherewithal to try to protect her and not disclose the identity. It can happen in any type of case, and if this court doesn't recognize the privilege and require more in terms of pleading an abuse of the privilege, then this is going to continue to happen, and women are not going to report instances of sexual harassment. It just will not happen.
Thank you, counsel. Time
Thank
has
you.
expired.
Thank you.
Mr. Nealon?
Good morning, Your Honors. May it please the court, my name is Paul Nealon.
Certainly.
My name is Paul Nealon, and I appear before the court today as counsel for the petitioners, appellees, Richard L. Dent and RLD Resources. The 224 petition describes a September 2018 meeting at RLD's offices at which two attorneys representing Constellation told Mr. Dent the allegations that had been made against him. Statements made by Constellation's attorneys at that meeting and Constellation's subsequent December 2018 letter were the basis of the verified 224 petition. Constellation gave Mr. Dent no information beyond that, none. At that meeting, Constellation's attorneys described person B only as an unnamed gentleman who said he saw Mr. Dent being drunk and disorderly at the Marriott Hotel on Adams Street in Chicago. That is what person B said. That is all that person B said. Constellation's December 2018 letter doesn't even mention person B. The December 2018 Constellation letter attached to the 224 petition refers to person C as the third-party investigator hired by Constellation who republished to Constellation the defamatory statements of A and B. And I'd like to take a moment out to just refer to two cases that the appellants rely on. One is Vickers and the other is Davis versus John Crane, Inc. And in both of those, attorneys were not the investigators. In Davis versus John Crane, Inc., the issue was drug use in a workplace, some factory someplace. So the employer, the VP of Human Resources, hired a private investigator firm, a firm called SOA. That's the firm referred to in the Davis versus Crane case. And undercover agents went into the factory, observed this, and then reported back to the VP. In Vickers, there were not lawyers doing this. They were VP of Human Resources and other non-professional, non-lawyer staff who were doing the investigation. The two Constellation attorneys who met with Mr. Dent in September 2018 identified themselves only as Constellation's attorneys. They did not identify themselves as investigator, the first mention of whom comes up in their December 2018 letter. And Constellation's December 2018 letter is not in conflict with anything in the 224 petition. In order to do what the appellant's counsel wants to do, which is have this court just focus on the language in the letter, there has to be a conflict between the exhibit to the 224 petition and what's stated in the 224 petition itself, and they are not in conflict. Nothing in the 224 petition says that person C is the two attorneys. The 224 petition says twice that C has never been identified, and the First District Appellate Court held that as well.
Are you satisfied now that the opposing side has announced person C as the two attorneys?
No, I'm not. And the reason for that is, I'll get to that in a moment, is what this would do is allow the respondent in discovery to basically dribble facts out in response to a 224 petition. Unlike low-cost movers, where we have one tort and one tortfeasor, We had Craigslist, and the tort in Craigslist versus low-cost movers was the flagging of ads, apparently improperly on a Craigslist website. Here, we have defamation. Each word, each statement in defamation is a separate count. So we have 3 tortfeasors and 3 causes of action. That's one reason why low-cost movers doesn't apply, but I have other reasons why it doesn't apply. The 224 petition also alleges that in the period after September 2018 and until the March 2019 filing of the 224 petition, Constellation refused to identify person C. They refused to identify person C. That's all that the 224 petition says about person C. Once the 224 petition was filed, Constellation realized that its strategy of providing to Mr. Dent as few facts as possible had backfired. In order to use the qualified privilege of an employee to report workplace harassment to the employer, Constellation needed to have more facts than it had divulged in the September 2018 meeting and more facts than it had stated in the December 2018 letter. And because the verified 224 petition was based on that September meeting and the December 2018 letter, that meant that Constellation needed more facts than were alleged in the 224 petition. So in every Constellation filing, from its 2615 motion in the circuit court to its brief in the first district, and now in its filings in this court, Constellation keeps revising history to add new facts to what the verified 224 petition states it told Mr. Dent at the September 2018 meeting. And Your Honor, in answer to that question, the reason why it's not sufficient just to identify it, if someone propounds discovery, they should get a formal answer to discovery. The 224 petition deserves that answer. And to say, here's one person, now go away, don't bother us anymore. I don't think that that's something that the court would want individual litigants to kind of take control of its own Rule 224 and other rules just like that. So Constellation claims that it has alleged these facts in its pleadings. And as a matter of Illinois law, Constellation's motions and briefs are not pleadings. The only pleading in this case is the 224 petition. And the only facts of record in this case are those alleged in the 224 petition. With all due respect, counsel for the appellants refers to a number of studies that have been done on workplace harassment and the willingness of reporters to come forward and report these facts. And I don't dispute here, but they are not in the record in this case. They are outside the record. And it's outside the record on appeal in this case for Constellation to state that person B, is a Constellation employee. It's outside the record on appeal in this case for Constellation to say B is a witness to any alleged harassment of person A. And it's outside the record on appeal in this case for Constellation to say that B, who was not at Constellation's 2018 golf party at the Shed Aquarium patio, and who was not at the 2016 golf party near Philadelphia, has any connection to any alleged sexual harassment of person A. In fact, it's a wonder how they even associated person B in this case. It is outside the record on appeal for Constellation to state that Constellation's third-party investigator, a singular noun, is really the plural duo of the 2 attorneys who visited Mr. Dent in September 2018. And it's outside the record on appeal for Constellation to state that the RLD parties really knew who person C was all along. Under well-settled Illinois law, this court must disregard Constellation's arguments about persons B and C that are based on facts outside the record on appeal in this case. Constellation moved to dismiss the 224 petition under Rule 2615. Therefore, for purposes of its motion, it has to accept as true all well-pled facts in that petition. This court should note that in the 2615 motion filed in the circuit court, Constellation based that motion solely on its allegation of a qualified privilege of the employee to report harassment to the employer. There is not one word in the 2615 petition that questions the adequacy of any fact allegation in the 224 petition. So their allegation now that somehow our claim that the statements of A, B, and C are false is somehow conclusory is something that they neglected to mention back when this case opened and they had the chance to file 2615. Constellation says that the First District Court of Appeal should be reversed because that court said that qualified privilege is an affirmative defense that may not be raised in a 2615 motion. But this court reviews the judgment, not the reasoning of the court below. And this court can affirm the First District's ruling on any basis that appears in the record. Constellation then argues that there is no basis in the record on which to affirm the appellate court's judgment because it claims the 224 petition pleads into the qualified privilege, but it does not plead any facts to overcome that privilege. That is, it doesn't plead any facts showing that the statements were published with actual malice, meaning that the statements were published with knowledge that the statements were false or with reckless disregard as to whether the statements were true or false. According to Constellation, the reason that the RLD parties cannot allege actual malice in this case is because Constellation, the employer, says they performed a good faith investigation of the harassment allegations that had been made against Mr. Dent. Furthermore, says Constellation, the fact of its investigation means that all of the defamatory statements are covered by the same qualified privilege of the employee to report workplace harassment to the employer. The definition of actual malice has been around for almost 60 years since the noted 1964 case, U.S. Supreme Court case of New York Times versus Sullivan. But I draw the court's particular attention to the words publisher and published in that definition of actual malice that has been around for almost 60 years. Ever since New York Times versus Sullivan, to show actual malice, the plaintiff has to show that the publisher of the defamatory statement published it with knowledge that the statement was false or with reckless disregard as to whether the statement was true or false. When Constellation argues that the 224 petition pleads into a qualified privilege, it studiously avoids mentioning who the publishers of the defamatory statements are. It neglects to tell the court which party can avail itself of the qualified privilege. Based on the allegations in the 224 petition, Constellation's investigation might help Constellation claim a qualified privilege, but that's no help to Constellation in opposing the 224 petition because the publishers of the defamatory statements at issue in this case are A, B, and C. They are not Constellation. And if you compare the other cases cited by the appellants in their brief, like Vickers, like Abbott, these are cases in which the employer was a publisher of the statement and was a defendant in the defamation action. We don't have that here. The potentially liable parties under Rule 224, and the First District saw this as well, the potentially liable parties under Rule 224 are A, B, and C, not Constellation. To accept Constellation's argument would require this court to revise the New York Times v. Sullivan standard of actual malice and sever the act of publishing the statement from knowledge of whether it was true or false. And here's why Constellation says that in order for the RLD parties to overcome the qualified privilege and show actual malice, they have to show that Constellation knew that A, B, and C's statements were false. Constellation tells this court that we have to show that Constellation accepted the statements of A, B, and C with reckless disregard as to whether A, B, and C's statements were false. That makes no sense whatsoever. First, because Constellation didn't publish any statement about Mr. Dent. Constellation is the party to whom A, B, and C published their defamatory statements about him. A, B, and C are the publishers of whose knowledge and reckless disregard are at issue in this case. And second, even if Constellation accepted with reckless disregard of whether A, B, and C's statements were true or false, that would not make one bit of difference because all of the contracts between Constellation and Mr. Dent and RLD were at will. So they could have a good reason, no reason, a bad reason. It doesn't matter. Reckless disregard would not matter at all. So contrary to Constellation's argument, the record in this case does provide a basis for this court to affirm the First District's ruling because the qualified privilege that Constellation presents doesn't apply to the potentially liable parties under Rule 224, and it doesn't apply to the respondent in discovery under Rule 224. And Constellation, it's just the respondent in discovery. It is not a potentially liable party, and the First District so held. And here's where both Constellation and the Circuit Court of Cook County went wildly wrong and got Rule 224 wildly wrong. The 224 petition makes it clear that no defamation action lies against Constellation because it didn't publish any statements about Dent. The 224 petition also makes it clear that no breach of contract action lies against Constellation because all of the contracts were at will. To get around this problem, both the Cook County Circuit Court and Constellation take dicta from low-cost movers for the proposition that the RLD parties can't just keep pressing their 224 pre-suit discovery until they find a defendant that lines up with their preferred cause of action. That's their rationale. On the record of the case, that is absurd. Low-cost movers has no application to this case. In low-cost, the 224 petitioner didn't even know if there were any parties who had improperly flagged its ads. It merely speculated, and that word appears in the case. It merely speculated that there were competitors of its who took down its ads saying they were inappropriate. Then Craigslist admitted that it was the party who took down low-cost ads. And let me sidetrack for a moment because this is another statement in the appellant's brief where they say that in low-cost, the website Craigslist somehow revealed in its pleadings that, yeah, we're the party. So that justifies our statement in the brief that person C, we've dribbled the name of person C. Constellation miscites that paragraph. It's not paragraph 18 as they cite in their brief, it's paragraph 5 in the low-cost opinion.
Counsel, can Constellation assert the qualified privilege on behalf of person A as an employer taking a complaint of sexual harassment from an employee?
No, the employee, any person asserting a privilege has the burden of making that privilege stand. And Constellation's privilege would be if Constellation were in the position of Abbott, if Constellation were in the position of the publisher in, of another statement, then that privilege would apply. Take Beck versus Coughlin, okay? Constellation would be in the position of Beck, who was the board chairman of the National Association of Women Business Owners, and who had received a report from a member that the past board chairman, had improperly directed a contract to her and charged her too much or whatever. So there were statements made, defamatory statements made about the prior board chairman in Coughlin versus Beck. But what happened was that Beck, who was the board chairman, reasonably relied on what Bush, who was the client of the former board chairman, told her about what the past chairman, Coughlin, had done. And so that would be analogous to the privilege here if Constellation were to assert it. If we were to file a suit against Constellation, which is one of the reasons why we say that there is no action against Constellation.
Let's assume they can assert the privilege. Is an averment denying the allegations enough?
We believe it is. We believe it is. We believe that if this court were to go along with the appellant's view that the allegation that something is false is not sufficient, this court will effectively rewrite about a century of defamation law. Because if you look at this court's decisions in other cases like Green versus Rogers, and every other case deciding what the elements of a cause of action in defamation are, they are that the statement is false. The statement is false. It's not why the statement is false. It's that the statement is false. And if this court goes on and says, oh, well, that's not enough. You need to say that, the person wasn't there. Well, that's a good question on a 224 when you don't know who the person is. How are you going to make that allegation? How are you going to do that, consistent with your obligations under Rule 137, to make sure you have a good faith pleading filed with a court? I don't see that. And the other problem with the appellants, oh, I see my time is up.
Thank you, Counsel.
Thank you, Your Honor.
Let me begin by answering, Justice Burke, your question. Was she an employee, and is that alleged in the petition? It's not in the petition, but it is in Exhibit B to the petition, which would be considered, and it says specifically that there were reports that his behavior included, among other things, the unwanted touching of a Constellation employee. So it was in the petition that she was an employee. And we did insert the conditional privilege on her behalf. She was not a party to the action, only Constellation was. So we believe we were entitled to do that with respect to an employee. Counsel also said that we only raised a conditional privilege in our motion to dismiss, and that we nowhere said anything about the privilege being abused. I quote from the motion to dismiss the memorandum specifically in the appendix at A43. Specifically, petitioners must allege not only that the statements were false, but that they were made in knowledge of falsity or reckless disregard for the truth. Moreover, the allegation of such knowledge of reckless disregard cannot be conclusory, but instead must be supported by specific factual allegations. We did indeed raise it, as we have here. Counsel also said there was nowhere in the petition that they alleged there had been an investigation. And nowhere did we identify the people involved as person C that interviewed him. If you read Exhibit B, which again, he attached to his petition, so it's part of the petition, it says, on September 14, 2018, there was a meeting between Dent, Grace Spatz, Theos McKinney, and Timothy Wright. The meeting was to allow Mr. Dent an opportunity to provide his recollection of the events described. The law requires Constellation to investigate reports of such behavior, and the EOC directs employees to conduct effective investigations. Although Mr. Dent denied the allegations, his denials were not credible, and the investigation concluded the reports accurately described his behavior. He says we didn't identify the investigators. I don't know how it could be more clear in Exhibit B that the people who interviewed him were the investigators. But then we went further and said, in our motion to dismiss, those are person C. And he still says, we don't know. That doesn't make any sense. What he's saying is formal receptions. You have to file some formal response saying person C are. Instead, we put in our motion to dismiss, here are the investigators, they're person C, but they're all entitled to a conditional privilege. That was the purpose for disclosing it. So for him to continually say and harp on before this court that we haven't identified who the investigators are is simply not true. It stretches the imagination. And furthermore, let's talk about, counsel talked about damages. He mentioned it was an at-will contract that we terminated based upon his behavior. We also said, and this is part of his petition, Exhibit B, to date, neither Exelon nor Constellation has disclosed the findings of the investigation to any third party other than in privileged communications with its lawyers. Constellation did not pass on or publish any statements that were as a result of that investigation. They did what they were supposed to do. They had an investigation. Who publicized this whole incident? Mr. Dent did in his petition 224 in a blog response that we attached to an exhibit or in a footnote to our reply brief. This defamation of his character was not done by Constellation having a confidential investigation, which they did not publish. There were no damages to him when we simply said that we are terminating an at-will agreement between the parties. So it really comes down to the issue is in a confidential investigation where there's no hint that it wasn't properly performed, should you have to identify then the victim? We would say unequivocally no. Do you have to identify the witness? No, because the witness is going to be sued for defamation. So the chilling effect is obvious, and that's what the studies have shown, and I think that's the value of the amicus brief. That's what the studies have shown, that people are not going to come forward and report these allegations unless they can be assured it can be held confidential. And if someone who is making those allegations is not able to come forward with something that shows it's abused, then a 2615 is appropriate. It should be dismissed with prejudice, and the case should be over. If this court decides they don't want the confidential privilege or allegations of abuse of that privilege to be alleged in a case where they don't know the identity, then we do know the identity of person C in this case. But what's going to happen, as I said before, is that it's simply going to arise again in the next complaint that's filed against the people that were disclosed, person C. They're going to seek discovery because that's their purpose. They want to find out who the victim is. And that's up to this court, whether they're going to allow that or not. We submit it should not. And we're asking this court to reverse the appellate court decision and to affirm the circuit court dismissing the case because petitioners pled into a qualified privilege, have not alleged sufficient facts to overcome that privilege, so the petition should be dismissed under Rule 2615 for failure to state a claim of defamation pursuant to this court's decision in Hadley, and secondly, or alternatively, because the petitioner's identity of at least one potential defendant has been satisfied through Rule 224. Thank you very much.
Thank you, counsel. Case number 126795, Richard L. Dent et al. Versus Constellation NewEnergy Incorporated et al. Will be taken under advisement as agenda number 18. Mr. Eden and Mr. Nealon, I thank you very much for your arguments this morning. You are excused at this time.